Hi, I'm Rudy, broker and owner of Real Property Management LoneStar in Austin, Dallas, and San Antonio. I'm here to walk you through how this residential leasing and property management agreement works and explain how we typically operate under it. Before we begin, a quick clarification. This agreement is a standard Texas Realtors form promulgated by the Texas Real Estate Commission and may only be used by licensed realtors. We're not providing legal advice in this video. The purpose of this walkthrough is simply to summarize what's in the agreement and how it works in practice. Because this is a standardized Texas Realtors form, the language itself can't be changed. Only the required blanks are completed, and I'll explain how the agreement is applied during management. The agreement outlines the specific services provided, how they're applied, and any limits that may apply, all of which are detailed in your signed agreement. Let's start with the basics. Who's involved in this agreement? That's what Section 1 covers. Section 1 identifies the parties and confirms who has legal authority to sign on behalf of the owner. As the property owner, you are entering into a formal management relationship with Real Property Management LoneStar. If the property is owned by an LLC, trust, estate, or other entity, this section confirms that the person signing has authority to act on behalf of that entity. You will also provide your contact information, including whether you consent to receive text messages. Our contact information is included as well, so you know how to reach our team in Austin, Dallas, or San Antonio. And by signing this agreement, you're appointing us as your exclusive agent to handle leasing and property management going forward. Section 2 of the agreement identifies the specific property we'll be managing for you. This is where the property address is listed, so there's no confusion about which home is covered under this agreement. If you're assigning more than one property, any additional properties may be listed in an attached addendum. This section also clarifies what's included with the property, such as appliances, garage remotes, or alarm equipment, so everyone has the same expectations during the lease. If an item is intended to stay with the home and be available to the resident, it should be listed here or in an addendum. If something isn't listed, it's generally not considered part of the rental property or included under the management agreement. Section 3 explains how long the management agreement is in effect. The agreement typically begins with an initial term, most commonly 12 months. The exact start and end dates are listed in this section. If neither party provides written notice before the end of the initial term, the agreement generally continues on a month-to-month basis. After the initial term, either party may end the agreement by providing written notice, as outlined in the agreement. It's also important to note that while the management agreement has its own term, the timing of a residence lease can affect how a transition is handled if the agreement ends. This section outlines how our management, leasing, and maintenance coordination services are structured in the agreement. The document uses standardized language required by the Texas Realtors form, but what's important is understanding what services are being provided and when they apply. First, a reserve is established and held in your trust account. This is not a charge, it's your money, set aside so routine and time-sensitive maintenance can be handled without delays. Next are our ongoing management services. These cover the day-to-day work required to operate the property, including compliance oversight, resident communication, maintenance coordination, financial administration, and readiness. We do not charge a monthly management fee when the property is vacant. Our leasing services apply when a new resident is placed. This includes marketing, showings, screening, lease preparation, coordination of move-in and move-out evaluations, and ensuring the property is positioned for a successful tenancy. Each time a resident renews, renewal services apply. These include pricing checks, lease coordination, documentation, and system updates to ensure a smooth transition. Maintenance coordination services apply when repairs or improvements are performed. This includes diagnosing issues, scheduling licensed and insured vendors, coordinating access, overseeing the work, and confirming completion. Emergency situations may be addressed immediately to protect the property or meet habitability and safety requirements as permitted by the agreement. Specific amounts, limits, and service selections are outlined in your signed property management agreement. This walkthrough is intended to explain how those services work in practice. If we assist with insurance claims or casualty events such as fire, water damage, or storm-related issues, additional coordination services may apply based on the time and complexity involved, as outlined in the agreement. In rare cases where we are required or requested to participate in legal matters related to the property, such as providing documentation, responding to subpoenas, or attending proceedings, time-based professional services may apply to cover the work involved. All applicable services and limits are detailed in your signed property management agreement. If you choose to end your property management agreement with RPM LoneStar, here's what to expect. Any outstanding balances under the agreement must be resolved in full before the account can be closed. If the property is occupied at the time of termination, the agreement outlines early termination and lease-related obligations. Depending on the situation, this may include services associated with managing the lease through its scheduled end or completing the transition responsibly. If the property is vacant at the time of termination, the agreement outlines a different termination structure, reflecting the reduced scope of services required. These provisions cover administrative work and services already performed, including leasing activity, compliance, and ongoing management responsibilities. For owners with multiple properties, termination provisions apply on a per-property basis, as outlined in the agreement. The agreement also includes offboarding services, which cover the preparation of final reports, reconciliation of the account, transfer of records, and coordination with a new manager if applicable. Please note that funds, deposits, and records cannot be released until the account is settled in full and written authorization is received. All details, services, and limits are outlined in your signed property management agreement. This section explains how reserves are handled under the standard Texas REALTORS AR Property Management Agreement. When you sign your property management agreement, a reserve is established and held in a trust account on your behalf. That reserve allows us to handle routine leasing and maintenance expenses, such as minor repairs or approved vendor work, without unnecessary delays that could impact the property or the resident. The reserve is not a fee. It remains your money and is used solely for property-related expenses so work can move forward promptly when needed. If the reserve balance drops below the required amount, the agreement allows us to replenish it, either from collected rent or by requesting additional funds to restore the balance. In most cases, the agreement outlines a standard reserve amount, commonly $500 per property, unless otherwise specified in your signed agreement. If a tenant gives notice or the management agreement is being terminated, the agreement allows for a temporary reserve increase, often up to 1 month's rent or a stated cap. This ensures sufficient funds are available for standard make-ready services such as cleaning, painting, repairs, or rekeying. All reserve requirements, limits, and conditions are detailed in your signed property management agreement. This section explains how different services are earned and applied under the property management agreement so there are no surprises later. Because this is a standardized Texas Realtors form, the agreement uses specific legal terminology. What matters in practice is what services are being provided and when they apply. Let's walk through the key services covered here. Ongoing management services. Our ongoing management services cover the day-to-day work required to manage your property, including compliance, oversight, coordination, and readiness, whether the home is occupied or vacant. Because these responsibilities continue regardless of occupancy, management services are earned throughout the term of the agreement. This ensures consistent oversight, responsiveness, and protection of your asset at all times. Leasing services. Leasing services apply when a new resident is placed in the home. These services include marketing the property, coordinating showings, screening applicants, preparing the lease, conducting move-in documentation, and placing a qualified resident. Leasing services are provided at the time a new lease is executed. Renewal services. Each time a resident renews or extends their lease, renewal services are required. These include pricing reviews, market analysis, lease coordination, documentation, and system updates to ensure a smooth and compliant transition. Renewal services apply when the renewal takes effect. Maintenance coordination services. When repairs or improvements are needed, we coordinate maintenance on your behalf using licensed and insured vendors. This includes diagnosing issues, coordinating access, reviewing estimates, overseeing work, handling warranty coordination when applicable, and ensuring completion meets standards. These services apply when repair or maintenance work is performed as outlined in the agreement. Important clarification. All service timing, limits, and conditions are detailed in your signed property management agreement. Our goal is full transparency, so you understand what work is being done, why it's necessary, and how it protects the value and long term performance of your investment. Broker services, how these situations are handled. This section covers a few less common services that may apply under specific circumstances. These aren't everyday items, and they only come into play when additional coordination or administrative work is required beyond standard property management. Administrative services. In some situations, we may collect tenant paid amounts such as application charges or returned payment items. When that happens, those amounts are retained by RPM LoneStar to cover the administrative processing compliance and system handling associated with those transactions. Insurance and legal coordination services. If we're asked to assist with insurance claims or casualty events such as fire, water damage, or storm related issues, we may provide claims coordination services on your behalf. This can include working with carriers, adjusters, vendors, and required documentation. These services are only provided when requested or necessary, and only when the situation requires additional time and involvement beyond normal management. Property sale coordination during management. If you decide to sell the property while we're managing it, we can provide sale related coordination services during the transition. This may include coordinating access for inspections, repairs, or vendors, and managing logistics while the property remains under management. We are not acting as your sales agent unless there is a separate listing agreement in place. This simply ensures continuity and protection of the property during the process. Third party programs and services. The agreement also discloses that RPM Lone Star may receive compensation from certain third party programs or service providers used in managing the property. This does not change your responsibilities under the agreement, and it does not affect our obligation to act in your best interest as your property manager. Closing context. We've already covered insurance requirements earlier, so this section simply documents how additional coordination services may apply in insurance related, legal, or sale related situations as outlined in your signed agreement. Our goal is full transparency, so you understand what work is being done, why it's necessary, and how it supports the long term performance of your investment. Sections 7 and 8 explain the authority you're granting us to act as your property manager. This authorizes us to act on your behalf to lease the property, collect rent, handle maintenance, coordinate vendors, send required notices, and follow applicable safety and housing requirements. We're authorized to make routine decisions within the limits you set and to act immediately in emergencies to protect the property and address required safety or habitability issues. This authority allows us to manage your home efficiently, stay compliant with Texas law, and avoid delays that could impact rent, safety, or habitability. While we handle the day to day operations, ownership decisions remain yours. We simply take care of execution so you don't have to. Now let's talk about how we handle repairs, especially emergencies, and what we need from you as the owner. When something breaks at your property, we step in to coordinate the repair on your behalf. That's part of what you've hired us to do. To make that work smoothly, there are two key pieces. First, we ask every owner to maintain a reserve fund, typically starting at $500. This is not our money, it remains yours, held in your account so we can address routine issues like a leaking faucet, a broken fan, or a faulty appliance without delay. But sometimes more urgent situations come up, and that's where Section 9 advances comes in. If there isn't enough money in your account and a repair needs to be made quickly, we may advance the cost to get the issue resolved without delay. When that happens, we'll document the expense, and the agreement outlines a prompt reimbursement timeframe, typically within 10 days. This allows us to act immediately when timing, safety, or habitability are at stake, without waiting for funds to clear first. Let's go over what the owner is responsible for disclosing in the property management agreement. This section is called Owner's Representations. By signing the agreement, you're confirming a few things about the property and your legal status as the owner. Here's a summary. First, you confirm that you have full legal ownership of the property, what's called fee simple title, and the right to lease it out. You're not under any other agreement that would prevent us from leasing it on your behalf. Second, you confirm there is no one else, like another person, bank, or association, who has first rights to buy, lease, or take control of the property. You're also stating that you're current on property taxes, HOA dues, insurance, and mortgage payments, and that the property isn't involved in any legal disputes. If the property is part of a subdivision with amenities like a pool or tennis court, you agree to tell us if there are optional user fees associated with those. You confirm that everything you share with us about the property is accurate to the best of your knowledge, and that anything we list or advertise for you doesn't violate any copyright laws. Finally, you authorize us to rely on and share these representations with prospective tenants as required. There are two other quick but important sections here.
Property condition.
As the owner, you agree to disclose anything that could affect the tenant's health or safety, and to fix those issues promptly as required by the Texas Property Code. You're also confirming that things like fences, gates, and pool enclosures meet local safety rules. Lead-based paint. If your home was built before 1978, you'll need to complete a special addendum about lead-based paint. Federal law requires that we give tenants a lead safety brochure and disclose any known hazards. Don't worry, we'll walk you through that if it applies to your property. This section ensures everyone's on the same page and that we're marketing and managing a safe, legally compliant rental. Your part? Just be honest, be clear, and we'll handle the rest. In this next section, we outline what we need from you, the property owner, to do our job effectively. When you hire RPM LoneStar, you're putting us in charge of managing, marketing, and leasing your home. But to make that work, we need your cooperation in a few key areas. Here's what that looks like in plain terms. First, you agree to work with us, not around us. That means you won't lease the property to anyone yourself or negotiate directly with prospective tenants. If someone contacts you, just refer them to us. We'll take it from there. Second, you agree not to sign any other leasing or management agreements with another broker while our agreement is in effect. You also agree to give us what we need to manage the property properly, including copies of any current leases, keys and access devices like garage openers or gate codes, passwords for smart locks or security systems, warranties for appliances or major systems, homeowner association contact details and documentation. If there's already a tenant in the property, we'll need any security deposits you're holding so we can manage those according to the lease and Texas law. You also commit to keeping us updated if anything about the property changes. If you become late on payments, like your mortgage, taxes, or HOA dues, or if you plan to list the home for sale, we just ask for reasonable notice. In short, this section makes sure we're all aligned. You trust us to manage the property, and in return, we ask for the tools and transparency to do that job well. Together, that's how we protect your investment and provide a great experience for your residents. Let's talk about insurance and what's required to protect your property, your finances, and our management team. At RPM Lone Star, we carry a lot of responsibility when it comes to managing your home. To protect everyone involved, we require each owner to maintain proper insurance coverage throughout the agreement. Here's what that includes. First, you'll need a public liability insurance policy with at least $300,000 in coverage, and it must name RPM Lone Star as an additional insured or co-insured. This ensures we're protected in case something happens at the property, like an injury or claim during management. Second, you must have property insurance that covers the full replacement cost of the home and improvements, including coverage for vacancy periods between leases. If you're enrolled in our Peace of Mind package, you're already taken care of. That package includes automatic coverage through our SureVestor Master General Liability (MGL) policy, which provides up to $1 million in coverage and satisfies all requirements. No action is needed from you. However, if you're on the professional or premium package, MGL is not included, and you'll need to provide your own policy and send us proof within 15 days. If we don't receive proof within that window, we'll automatically add your property to the MGL policy and charge $20 per month, just to ensure you're not exposed. This way, every property we manage is fully insured and no one is left at risk. If you have questions about getting covered or want to upgrade your plan, we're here to help. Let's talk about what happens if you ever decide to end your property management agreement with RPM Lone Star. We understand that situations change. Whether you're selling the home, moving back in, or transitioning strategies, this section explains how that process works. When the agreement ends, any outstanding balances related to services already performed must be settled, as outlined in the agreement. If the property is occupied at the time of termination, the agreement explains how remaining management responsibilities are handled through the end of the lease or through a defined transition period. This ensures continuity for the resident and protects the value of the property during that time. If the property is vacant, the agreement outlines a different transition structure, reflecting the reduced scope of services required. To close things out properly, the agreement includes a one-time off-boarding service. This covers the administrative and coordination work required to complete the transition professionally. That may include final accounting and record delivery, processing remaining vendor invoices, handling utility or security deposit transfers, coordinating with a new manager if applicable. Please note that funds, deposits, and records can only be released once the account is settled and written authorization is received, as required by the agreement. The goal of this process is simple: to make sure that even after the agreement ends, nothing is left unresolved and everything is handled cleanly, legally, and transparently. All details and limits are clearly outlined in your signed property management agreement. This section of the agreement outlines how routine operating costs and broker cooperation are handled during management. Like any property operation, there are occasional out-of-pocket expenses involved in managing a home. These can include things like copies and postage, long-distance calls, notary services, mileage or parking for property visits, and professional photos or videos used for marketing. Here's our approach at RPM LoneStar. We don't itemize or bill separately for routine administrative expenses. These costs are already built into our management services. No nickel and diming, no surprise invoices, just clear, straightforward pricing. The agreement also explains how we cooperate with outside real estate agents to help lease your property faster. If another agent brings us a qualified tenant, we may pay that agent a referral commission. That commission comes out of our leasing services, not as an additional charge to you. This section is included purely for transparency so you understand how cooperation works behind the scenes. From your perspective, nothing changes. You receive the same leasing and management services you agreed to, with no hidden costs and no unexpected adjustments. The bottom line is simple. You know what services you're paying for, what's included, and how everything is handled. This section of the agreement explains how responsibility and risk are allocated during property management. At RPM Lone Star, we manage your property carefully and professionally. That said, certain situations are outside of our direct control. For example, we are not responsible for injuries or damages caused by third parties, such as vendors, inspectors, or contractors, criminal activity at the property, weather related events like freezing pipes or storms, structural or environmental conditions, or issues that arise from violations of laws or ordinances we didn't create. The agreement also clarifies that we're not responsible for tenant actions that violate their lease or for items that require owner decisions or disclosures. This section also explains the owner's responsibility to indemnify the broker in specific situations. In plain terms, that means protecting the management company if an issue arises due to incorrect information provided, owner decisions, or agreements entered into outside of our control. This isn't about shifting blame, it's about clearly defining roles so we can manage your property efficiently without assuming legal responsibility for issues we didn't cause. Clear boundaries like this allow us to focus on what we do best: protecting your property, staying compliant with Texas law, and managing risk responsibly. In short, we manage the property with care, and this section ensures both you and our team are protected when circumstances fall outside day to day management. This section explains how issues are handled if there's ever a dispute or a breakdown in the agreement. The goal here isn't conflict, it's clarity and fairness. If either party doesn't meet their obligations under the agreement, the contract outlines the available remedies. That can include recovering unpaid amounts, addressing collection costs, or using other remedies allowed under Texas law. This applies to both sides. For example, if an owner doesn't maintain required insurance, or if a broker were to stop performing agreed services, the agreement explains how that situation is addressed. Importantly, the agreement emphasizes resolving issues without immediately going to court. Mediation first. If there's ever a disagreement that can be resolved informally, both parties agree to try mediation first. Mediation is a structured conversation with a neutral third party, chosen together, to work toward a practical resolution. The cost of mediation is shared, and this step is designed to avoid unnecessary legal action while encouraging cooperation and faster outcomes. If a legal dispute occurs, only if a dispute moves beyond mediation and into court does the agreement address recovery of legal costs. In that case, if one party prevails, the court may allow recovery of reasonable legal expenses from the other party. This provision exists to discourage unnecessary lawsuits and to protect whichever party is ultimately found to be in the right. These sections are rarely used, but they're important safeguards that ensure disputes are handled fairly, professionally, and with clear expectations on both sides. The overall intent is simple: resolve issues efficiently, protect everyone involved, and keep the focus on managing the property successfully. This section covers a set of special provisions and addenda that support how we manage your property day to day, especially around maintenance, emergencies, and operational logistics. These provisions are designed to give us the authority to act quickly, responsibly, and in compliance with Texas law without unnecessary delays. First, the agreement clarifies how emergency repairs are handled. In situations involving health, safety, or habitability, such as HVAC failure during extreme temperatures, water leaks, or other urgent issues, we are authorized to act immediately to protect the property and comply with legal requirements. That means we don't wait for approval when time is critical. Our priority is stabilizing the situation, protecting the asset, and ensuring the home remains habitable. The agreement also addresses mold-related conditions. If a resident reports suspected mold, or if we reasonably believe conditions exist that could lead to mold growth, we may coordinate a professional inspection. This allows us to identify issues early, limit liability, and determine appropriate remediation steps if needed, all in accordance with Texas law. During extreme weather events, the agreement allows us to take temporary protective measures. For example, we may install temporary heating or cooling equipment to maintain habitability while permanent repairs are pending. These measures are intended to protect the resident and the property, but they are temporary by design and not a substitute for full repairs. Maintenance coordination and vendor management. The special provisions clarify how maintenance coordination works. We manage pricing, vendor selection, scheduling, and oversight on your behalf. Vendors perform the work. We manage the process, documentation, and accountability, so there's one clear point of responsibility. This ensures consistency, proper records, and protection of your investment over the long term. This ensures consistency, accountability, and proper records for your property. Reserves and vacancy transitions. During vacancies or lease transitions, the agreement allows for temporary adjustments to reserves to ensure sufficient funds are available for make-ready work. This helps avoid delays and allows us to prepare the home efficiently for the next qualified resident. Annual statements and reporting. Finally, the addendum confirms that annual financial statements are provided as part of our reporting process, giving you a clear summary of income and expenses for tax and record-keeping purposes. These special provisions exist so we can manage your property proactively, not reactively. They give us the flexibility to respond to real-world situations, protect your investment, and keep operations running smoothly, all while staying aligned with your property management agreement. This last section is standard boilerplate language found in most management agreements. It explains how the agreement is interpreted, enforced, and who is responsible for what. First, this document represents the entire agreement between you and RPM LoneStar. Any changes must be made in writing and signed by both parties. There are no side agreements or verbal modifications. Everything that governs our relationship is contained here. The agreement is legally binding, not only on you, but also on your heirs, successors, or assigns. If more than one person signs as the owner, each signer is fully responsible for the obligations under the agreement. Texas law governs this agreement, and if any single provision is ever found unenforceable, the rest of the agreement remains in effect. Official notices must be provided in writing, and the agreement includes standard language regarding singular and plural terms and copyright protections. This section exists to make sure everyone is clear on how the agreement works legally, so there are no surprises later. This section covers legally required disclosures and safety rules under Texas law. Let's break it down simply. Broker compensation. Any fees shared between brokers, like referral fees, are not fixed by MLS or realtor associations. These arrangements are private and competitive. Fair housing compliance. RPM LoneStar follows federal fair housing laws. We do not discriminate based on race, color, religion, national origin, sex, disability, familial status, sexual orientation, or gender identity. Local laws may add more protections. MLS submissions and personal safety. We may post your property details to the MLS and other listing services. We advise you to remove or secure jewelry, valuables, and prescription meds before a showing. Texas Property Code Security Requirements. Your property must meet certain security device standards, including window latches on all windows, keyless deadbolts on every exterior door, pin locks and handle latches on sliding glass doors, peepholes or door viewers on external doors, smoke alarms in the required locations. We're also required to rekey the property and test smoke alarms before every new tenant move-in. Protecting your financial information. We strongly advise you not to send personal or financial info via unsecured email, like bank account numbers. This reduces your risk of fraud or identity theft. Foreign owner tax obligations. If you're a foreign person under US tax law, RPM may need to withhold a portion of your rental income and send it to the IRS. This includes non resident individuals, foreign owned corporations, or trusts. If you're not sure if you qualify, please consult a tax professional. You'll be asked to confirm whether or not you're considered a foreign person by checking a box when signing the agreement. Legal disclaimer. RPM Lone Star cannot give legal advice. If you have any questions about this agreement, we always recommend talking to your attorney before signing. These requirements protect you, your residents, and ensure we stay fully compliant. That wraps up our step-by-step walkthrough of the property management agreement. At RPM Lone Star, we know contracts can be overwhelming, but our goal is to make the process clear, transparent, and fair for everyone involved. This agreement protects you, your property, and our working relationship while giving us the tools to manage your investment effectively and responsibly. If you have any questions, don't hesitate to reach out to our team. We're happy to walk through anything you'd like to clarify. Thank you for choosing RPM Lone Star. We look forward to earning your trust every day.